Good morning, class. Today's topic is Chapter 4, Limited Partnership. So remember, this is the last topic for partnerships. After this, we will proceed to private corporations. So let's begin with the definition. Very simple. Remember, this is not a new concept. We already studied this when we discussed the different kinds of partnership. A limited partnership is only one of the several kinds. And remember, when we discussed this before, we already defined it, and also we already discussed the composition of a limited partnership. Anyway, in 1843, remember, it defines a limited partnership. Ano ang sabi niya? A limited partnership is composed of two or more persons, as is with all kinds of partnership. And yung two or more persons na yon, they are at least the membership is composed of at least one general partner and one limited partner. So, yun ang kailangan nyo tandaan. In a limited partnership, there is a general partner and there is also at least one limited partner. May purpose ang general partner sa isang limited partnership. So, anyway, remember also that a limited partner is not bound by partnership obligations because it does not deal with third persons. The only obligation of a limited partner in a limited partnership is to give contributions to the partnership. After niyang mabigay yung contribution niya, wala na talaga siyang papel sa isang limited partnership. So, as to third persons, as to partnership obligations, a limited partner is not liable. What else? Also, remember that limited partnership can enter into same business ventures carried on by general partnerships. Yan. So, characteristics of a limited partnership. Number one, it is formed by compliance with the requirements of law. So, anyway, we will discuss that later on. Number two, it must have a general partner. And the purpose of the general partner must be to control the business and to be personally liable to creditors. What does it mean to be personally liable to creditors? They will be liable up to their separate properties. So, yun ang kailangan nating tandaan. That is the purpose of a general partner. What else? Number three, there must be one or more limited partners, at least one limited partners who will contribute capital to the business and remember also will share in the profits. But again, I will emphasize this, a limited partner will not participate in the manage of the business. And remember also that your limited partner has a limited liability. Kaya nga siya tinawag na limited partner. Ang limit ng kanyang liability is only up to the capital contribution. So they are not personally liable for partnership obligations. What else? Please remember also that limited partners may ask for a return of their capital contributions at a stipulated time or after complying with the requirements prescribed by law. Later on, you will know that. Number 5, partnership debts are paid out of partnership assets. And if partnership assets are insufficient, remember the individual properties of general partners. As we have already discussed, a general partner is liable up to their separate properties. So, such statutory requirements, meaning requirements provided by law, by statute. Kaya nga siya statutory requirements. So, the first requirement in the formation of a limited partnership is to draft yung articles of limited partnership or yung certificate of limited partnership. They are, remember, the same animals. So, yung certificate or articles of limited partnership will contain the matters enumerated in 1844. It must be signed and it must be notarized. Kaya nga sworn to, meaning it is notarized. So the contents of the certificate of limited partnership are, number 1, the name of the limited partnership. It must include, remember, the word limited para magkaroon ng indication of its limited liability ng mga ibang partners. And also, pwede nyo rin gamitin yung abbreviation na LTD. We already studied that in Chapter 2. What else? Number 2, the character of the business, location of the principal office, name, place of residence of each member. So, please indicate whether they are general partners or limited partners. What else? Term of the partnership, amount of cash contributed by each limited partner. If it is not cash, at least the description of the property, valuation, or appraisal of the property na contributed ng mga limited partners, kailangan mo siyang ilagay. What else? Additional contributions if they are to be made at a future time, tsaka kailan sila gagawin. Additional contributions of the limited partners. What else? Time of return of contributions. So, ilalagay din yun sa certificate of limited partnership. What else? Share of the profits or compensation by way of income which will be received by a limited partner because of his contribution. Ilalagay nyo dyan. Right of limited partner to appoint a substitute or an assignee. What else? Also, the right given to admit additional limited partners and the right given to preferred limited partners. What else? And the right given to general partners to continue the business in case of retirement, death, insolvency, insanity, etc., etc. In case there is a ground for dissolution, if there is a right given to the general partners to continue the business, kailangan ilagay din sa certificate yan. And the last one is the right, if given to limited partners, to receive a return of their capital contribution other than in cash. So, a general rule is that return of contribution will be received in cash unless there is a stipulation in the certificate. Yan, allowing the return of something other than cash. So, remember, class, what the law requires here is substantial compliance. Yan. So, substantially, the partners must comply with the requisites in Article 1844. Also, remember, strict compliance is not required. Now, what you have to remember also about limited partnership is that you must file for record yung certificate or articles of limited partnership sa SEC or Securities and Exchange Commission. Why? Because remember, in a limited partnership, this is an exception to the general rule. The general rule being that a partnership is a creation of agreement by the parties. If you remember in Chapter 1, we already discussed this. Sabi natin, a partnership is a consensual contract, meaning it is perfected by mere consent. A agrees, B agrees, absent any details or specifics with respect to the partnership, absent any contribution, there is already a perfected contract of partnership. Walang contribution, wala pang pinag-usapan kung anong business, basta nagkaroon ng agreement, perfected na ang contract of partnership, subject to two exceptions. In case immovables are contributed, and number 2, in case of a limited partnership. So as a general rule, class, really, a partnership is created by agreement. Once there is an agreement, may partnership na yan. Kasi ang dali niyang i-perfect ng contract. Now, in case of a limited partnership, this is the exact opposite. Because a limited partnership is a creation of law. Now, kung ang general partnership creation of agreement, this is creation of law. Why? Because you have to comply with the statutory requirements before magkakaroon ng isang limited partnership. If you do not comply with the statutory requirements, hindi mo pwedeng i-limit ang liability ng ibang mga partners. So, walang limited partnership if you do not comply with the requisites. So, the requisites, certificate of limited partnership, signed, notarized, obviously this must be in writing, or else paano mo isa-sign yan, and filed to the office of the SEC, containing the matters enumerated for in 1844. Substantial compliance is the only requirement. What else? Rules regarding limited partners, marami ito actually. All throughout the chapter, makikita nyo ang mga rules regarding limited partners. Unahin natin yung rules regarding contribution, 1845. Contribution is only money or property, hindi pwedeng services. Because if you contribute services, you are an industrial partner. Remember that. We already discussed this in Chapter 1. Now, if you are an industrial partner, automatically you become a general partner. So, again, Pagka services, matik kang general. Hindi ka pwedeng maging limited partner. So, sabi ng law, para maging limited partner, you should only contribute cash or property, but not services. Yan. Usually, the contribution is made before the formation of the limited partnership. Although in the certificate of limited partnership, pwedeng magbigay ng additional contribution. Yan. What else? What about if there are unpaid contributions as in 1858? So, remember, in 1858, sabi, kailangan mong bigay yung contribution mo. If not, you are liable to the partnership. Kung ikaw ay limited partner, give your contributions to the partnership, or else liable ka sa partnership. Now, what if there is a difference between your contribution as stated in the certificate and your actual contribution? In the certificate, it is 10,000. In your actual contribution is only 7,000. Remember, you are liable for the difference. Yan. Difference between the amount of actual contribution and that stated in the certificate. Yan. And also for any unpaid contribution, you will agree to make at a future time. This can refer to your additional contribution. So, liable ang limited partner para doon. What else? Also, in 1858, additionally, your limited partner is liable to return contribution even if lawfully received. When? Number one, if there are still liabilities to be paid. Actually, marami din to later on. If there are still liabilities to be paid, pero natanggap na niya ang kanyang contribution, naibalik na yung contribution niya, still liable to return yung contribution as long as there are liabilities. Bakit? Kasi, remember, later on you will know pala, that before the contribution of a limited partner is returned, kailangan wala ng liabilities yung partnership sa third persons, or assets are more than the liabilities. Liability as a trustee, in addition to that, number one, specific partnership property stated in the certificate as contributed but which has not been contributed. So here, the limited partner is trying to contribute yung property but hindi talaga siya binigay. Let us say, nasa pangalan pa niya. Hindi na sa kanya yon, but it is, remember, held in trust for the benefit of the partnership. So, a limited partner wants to contribute a parcel of land, hindi pa niya binigay, it does not belong to him already, but he holds it as a trustee for the partnership, kasi partnership property na yan. But else, number two, specific property of the partnership which has been wrongfully returned to him. So, nagbigay ang partnership ng specific property, but it must not belong to the limited partner, but again, held in trust by the limited partner on behalf of the partnership. What else? Also, money wrongfully paid or conveyed to him on account of his contribution. So, ito yung tinutukoy ko dito sa paragraph na ito. So, contribution is returned, but it is wrongfully paid because probably there are still liabilities to be paid. He has to return it. If hinold niya yung money wrongfully paid, he is holding it not as owner but only as trustee of the partnership. Other property also wrongfully paid or conveyed to him on account of his contribution held only in trust in favor of the partnership. 1858 again, requisites for waiver or compromise of liabilities. Here, wini-waive yung liability ng isang limited partner if there is consent of all partners, and the waiver will not prejudice partnership creditors. Yan. So, remember, pwedeng ma-waive yung liabilities ng isang limited partner. What else? 1846, there is obviously a liability if the name of a limited partner appears in the partnership name. Because the general rule is that only general partners can include their name in the partnership name. So, if you are a limited partner, you include your surname in the name of the partnership. Surprise, you are liable as a general partner, but without the rights of a general partner. So, liability mo pang general, rights mo hindi pang general partner. So, if you deal with third persons, you will become liable as a general partner because you included your surname in the partnership name. Now, third persons with actual knowledge of this, hindi ka pwedeng actual knowledge of your status as only a limited partner, hindi pwedeng i-apply itong rule na to. Meaning, the liability is still that of a limited partner. What else? Obviously subject to exceptions, as in 1846. The exception is number 1. It is also the surname of a general partner. So, hindi kasi ikaw ang tinutukoy ng surname na yon. So, may kaapilyado kang general partner. Of course, hindi ikaw ang tinutukoy doon. So, even if your surname appears to be included in the name of the partnership, you are not liable as a general partner because the surname does not refer to you, it refers to another partner. What else? Number 2, prior to the time when the limited partner became such, the business has already been carried on under a name in which his surname appears. So, dati nang ginagamit yung surname mo sa surname ng partnership, probably because it refers to a partner who entered before you. But remember here, class, again, the surname does not refer to you. That's why your liability, even if your name seems to be included in the partnership name, the liability remains the liability of a limited partner kasi you fall under the exception. What else? 1847, there are false statement in the certificate of limited partnership. So, the effect here, remember class, is that yung limited partner, if merong false statement and a third person relies on the false statement, the limited partner shall be liable. Yan. Pero nowhere in the law does it say that the limited partner will be liable for as a general partner. But sinabi lang may liability. So, the liability, meron siyang requisites before it is applied. So, the partner knew the statement to be false and he has an opportunity to amend or file for cancellation of the certificate but he failed to do so. Number 2, person seeking to enforce liability has relied upon the erroneous or false statement in transacting with the partnership and because of his reliance on the false statement, he suffered loss as a result. So, remember here, class, let us say, limited partner, ang contribution niya as appearing in the certificate of limited partnership is 10,000, but he only contributed 5,000. If a third person relied on that erroneous statement in the certificate, tapos ikaw naman na limited partner, alam mong false yon, meron kang opportunity to correct, you did not correct, tapos itong third person na to relied on the misrepresentation or error, and he suffered loss because of his reliance on the false statement, remember, the limited partner will be liable. Yun lang sabi ng law, liable, period. What else? 1848, participating in the management of a partnership. Remember, class, kaya may general partners sa isang limited partnership is that the general partners will manage the partnership. Now, what if the limited partner interferes in the management of the partnership? Nakialam siya, hindi naman dapat. He is liable as a general partner. So, yun ang magiging consequence nun. The limited partner will be liable as a general partner if he becomes involved in the management of the partnership. So remember what the law refers to here is active management of the partnership, not merely giving of advice. What else? Pwede ka naman magbigay ng advice, alangan. Tapos, also, yung bare grant of authority, meaning binigyan lang, mere grant of authority na mag-manage ang limited partnership without actual exercise of the power to manage is not sufficient to make the limited partner liable as a general partner. Dapat active exercise, active use of the power to manage, active management para maging liable as general partner ang isang limited partner. In 1849, this talks about additional limited partners. So, remember, this right must be granted in the certificate of limited partnership. Now, if nagkaroon na ng additional limited partners, obviously, there must be an amendment because in the certificate, you have to name the limited partners. You have to indicate also the addresses and the contributions of the limited partners. So, there has to be an amendment according to, if I'm not mistaken, 1865 ang amendment. So, anyway, what else? 1851, rights of limited partners. So, medyo madami ito. But, surprise, these are actually the rights also of a general partner. So, number 1, right to require partnership books be kept at the principal place of business. We already discussed that, Chapter 2. Right to inspect and copy partnership books in relation with 1805 also, already discussed. Right to demand true and full information, already discussed. Right to demand a complete and formal accounting, already discussed, Chapter 2. What else? Right to ask for dissolution and winding up by decree of court. So, the winding up here is judicial winding up, judicial dissolution pala. What else? Right to receive share of profits or other compensation by way of income. Obviously, nakakatanggap ng profits ang isang limited partner. What else? Right to receive return of his contribution. Yan. Again, in 1857, sabi niya, partnership assets must be in excess of the liabilities before there is a return of contribution. How about 1854? Limited partner, can they transact business with the limited partnership? Obviously, even a general partner can transact business with the partnership. Paano pa kaya yung limited who is, remember, a mere investor? So, pwede siyang makipag-transact sa kanyang sariling partnership because there are allowable transactions. So, in 1854, sabi niya ang allowable transactions, granting loans to the limited partnerships. Pautangin mo ang limited partnership that is allowed. What else? Transacting other business with the partnership, also allowed. Yan. What else? Receiving a pro rata share of the partnership assets with general creditors if he is not also a general partner. So, you have to remember here, class, that he has the status of a creditor. Creditor third person. Parang ganun ang treatment sa kanya. So, he will receive a pro rata share of the partnership assets as if he is a general creditor. What else? There are also, remember, prohibited transactions, meaning hindi pwedeng pasukan ito ng isang limited partner with respect to business transactions with his own limited partnership. So, number 1, he cannot hold or receive as collateral security specific partnership property. So, bawal isang sa isang limited partner ang specific partnership property. Yan. This is a prohibited transaction. What else? He cannot receive any payment, any conveyance, any release from liability if partnership assets are not sufficient to discharge partnership liability. Yan. So, yun ang kailangan yung tandaan dyan. What else? Compensation by way of income. So, ito yung share ng limited partner sa profits yan ng isang partnership. But remember, before a limited partner will receive a share in the profits or compensation by way of income, the condition is that the partnership assets is in excess of liabilities after the payment. Yan. What else? 1857, return naman ng contribution. Kung kanina, profit, 56, 57, the return of contributions of a limited partner. So, the rule is that the contributions will be returned only if all liabilities of the partnership have been paid. Kung hindi pa nabayaran, there are sufficient assets to defray yung or to pay yung liabilities. Again, assets exceed liabilities. What else? Consent of all members, general and limited partners have been obtained, except hindi na kailangan ng consent ng lahat ng members if the return may be rightfully demanded. Later on, you will know when the return of contribution is a matter of right on the part of the limited partner. Number 3, there is a cancellation of the certificate or amendment of the certificate to reflect yung withdrawal or the reduction of the contribution. So, ito ang requisites bago maibalik ang contribution ng isang limited partner. Also, remember that the return of the contribution is a matter of right on the part of a limited partner. Right niya talagang ibalik na yung kanyang investment. If, number 1, dissolution of the partnership, alangan naman, nagdi-dissolve na ang partnership, ayaw pang ibalik ng partnership ang kanyang contribution, hindi pwede yon. Number 2, arrival of a date specified in the certificate for the return. Remember, sabi ko sa certificate, there must be a date specified for the return of the contribution. So, pagka dumating na yung date specified, as a matter of right, the limited partner can demand for return of contribution. And number 3, if walang nakalagay na date or fixed date for the return of the contribution after expiration of 6 months from notice in writing. Yan. So, notice in writing, 6 months. Pagka nag-expire na yon, it is a matter of right ng isang limited partner to recover his contribution from the limited partnership. Also, in 1857, in addition to all of that, a limited partner may ask for dissolution of the partnership if, number 1, his demand for return of his contribution is denied. So, meron na siyang right to receive yung kanyang contribution, but the right is denied even if he is entitled. So, pwede niyang ipa-dissolve yung partnership. Kasi bakit nga naman ayaw ibalik yung contribution niya? Pwede nang ibalik sa kanya. Right na niyang makuha. Di ipa-dissolve na lang niya so that he can acquire or obtain yung kanyang, para maibalik sa kanya yung kanyang contribution. What else? When his contribution is not paid, although he is entitled to its return because the other liabilities of the partnership have not been paid or partnership property is insufficient for payment. So, in number 2, the limited partner is entitled to return but the assets are less than the liabilities. So, pwede niyang ipa-dissolve yung partnership noon para magkaroon na rin ng accounting and later on return of yung kanyang contribution. If meron pang natira. Yan. So, anyway, please remember also 1866, a limited partner is a mere contributor to the partnership. Anong ibig sabihin ng mere contributor to the partnership? Ang ibig sabihin niyan, class, investor lang siya. He invested only money. So, pagka siya ay nag-invest ng money, he is, according to this, practically a stranger in the limited partnership and his liability is limited to the capital contribution. No right to participate in the management, no right to control the business. Dahil nga naman siya ay spectator lang, like a stockholder in a corporation. Remember that if there are actions against the partnership or kung mayroong action ang partnership against third persons, in short, kung dinimanda ang partnership, kung nagdemanda ang partnership, dinimanda or nagdemanda, remember, the rule is that limited partners are not proper parties to any action to be filed by the partnership or to be filed against the partnership. So, wala silang right na magdemanda. And also, kung ikaw ang magdedemanda sa partnership, ikaw ay third person creditor, hindi mo sila kailangang idemanda because technically, class, ano lang sila, contributor ng pera or property, investor lang sila. So, what are the exceptions? So, a limited partner is a proper party in the following cases. Number 1, if the object is to enforce his individual rights against the partnership. So, ang i-enforce ng limited partner is yung right niya against the partnership. Meaning, let us say, ayaw ibalik yung kanyang contribution, he is asking for damages, yan. So, obviously, he has personality to file against the partnership. Yan. What else also? On the other hand, limited partner is also a proper party. Pwede siyang idemanda ng partnership if the proceeding is only to enforce his liability on the partnership. Ayaw niyang magbigay ng additional contributions or yung kanyang mga unpaid contribution, the deficiency, the difference, pwede siyang idemanda ng partnership para lang i-enforce yung kanyang liability. In this case, again, he is a proper party. What else? Creditors can also sue or file an action or file a case against limited partners if yung limited partner kumuha siya ng sums from the capital of the firm. Yan. So, kung meron siyang kinuhang pera from the partnership, pwedeng mag-file ng action ang mga creditor against the limited partner. Yan. What else? Also take note of your preferred limited partner. 1855. Ang preferred limited partner is, remember, meron siyang preference. Pagka meron kayong preferred limited partner, that right must be stated in the articles or certificate of limited partnership. So, remember, agreement of all members, general and limited partners, and there is a statement in the certificate, pwede kang magbigay ng preference sa mga ibang limited partners over other limited partners. So, ang tawag sa mga may preference over other limited partners ay preferred limited partner. So, what are the preferences? Remember, the preferences are as to return of his contributions. So, mauna muna yung preferred limited partner na balik ang contribution niya, tapos dun palang ibabalik yung sa ordinary limited partner. Kasi nga preferred siya eh. So, sa computation ng liability, ay sa return ng contributions, kailangang mauna siya. What else? Compensation by way of income. Una niyang marireceive ang kanyang compensation or profits by way of income, and also such other matters as designated by the partnership. So, pwede siyang magkaroon ng preference doon. What else? So, a substituted limited partner is originally an assignee of a limited partner. So, remember, in 1859, binigyan natin ng karapatan ng isang limited partner to appoint an assignee. Yung assignee ng isang limited partner is much like the assignee as already discussed in 1813. Remember, in 1813, the assignee is allowed to receive profits and allowed to receive surplus after dissolution, which pertains to the assignor. In case of an assignee of a limited partner, the assignee is entitled to receive a share in the profits or other compensation by way of income or to a return of the contribution of the limited partner. Remember, class, ang contributions ng limited partner, pwedeng ibalik yan. So, yung assignee niya ang makaka-receive. Again, in both cases, the assignee has no right to require information, account, and to inspect partnership books. Now, your assignee can become a substituted limited partner if, remember, there is consent on the part of all of the partners doon sa limited partnership. So, a substituted limited partner is defined as a person who is admitted to all the rights of a limited partner who has died or has assigned his interest in the partnership. Now, to become, for an assignee to become a substituted limited partner, these are the requisites. Number 1, all the members must consent to the assignee becoming a substituted limited partner. Or kung hindi naman lahat nag-consent, there is a power granted to a limited partner to give an assignee the right to become yung limited partner. What else? Certificate must be amended in accordance with 1865, and also the certificate as amended must be registered with the SEC so that your your assignee will become a substituted limited partner. What else? In case of failure to create a limited partnership, you did not follow the provisions of law. So there is a failure to create a limited partnership. So if you do not, there is no substantial compliance in good faith with the requirements, hindi pwedeng ilimit ang liability ng mga limited partners. So ineffective siya, at least for persons who do not recognize na siya ay isang limited partner. Now, also, there can be, if there is a failure to create a limited partnership, there can also be failure to become a limited partner. So, kailan nangyayari yon? If the name of a limited partner appears as in the certificate as a general partner, or wala siyang designation as a limited partner. So, yun ang kailangan nating tandaan. Now, what is the status of a person na akala niya siya ay isang limited partner? So, if he erroneously believes that he is a limited partner, he is not liable as a general partner if he exercises his rights as a limited partner. Provided class number 1, pagka nalaman niya yung mistake, he will renounce his interest in the profits of the business or other compensation by way of income. So, tandaan nyo na if there is failure to become a limited partner, or yung taong ito, he fails to register as a limited partner, hindi naman siya matik na liable as a general partner, provided these conditions are presented. So, number 1, pagka nalaman niya yung mistake, he renounces his right to the profits and other compensation by way of income. His surname does not appear in the partnership name, and he does not participate in the management. So, in that case, class, itong limited partner na to, although erroneously designated as a general partner, or there is failure to designate him as a limited partner, is not liable as such general partner. Remember also that there is a necessity of renouncing interest. Yung renouncing of interest will happen if the interest of such limited partner na hindi na i-register as a limited partner is sold to the general partners before the partnership becomes liable to third persons. Yan. How about general partners? These are the rules. Siyempre may general partners pa rin sa isang limited partnership. Rights, powers, and liabilities. Again, uulitin ko, there is right of control and there is unlimited personal liability on the part of general partners. So, general partners will take control or manage the business of the partnership, has all the rights and subject to all the liabilities of a partner in a general partnership. Yan. So, yung general partner in a limited partnership has the same rights and liabilities as a general partner in a limited partnership. What else? Number 2, remember that even if that is the case, meron siyang control sa business, he cannot perform acts of administration or acts of strict dominion as defined in 1850. So, what are the acts of... bumalik siya. So, remember, class, yung acts of strict dominion or acts of ownership can be performed only if agreed to by all general partners and all limited partners. Yan ang kailangan nating tandaan. So, what are the acts of strict dominion? Number 1, SICPA Act. Any act in contravention of the certificate. Number 2, any act which will make it impossible to carry on the business of the partnership. Confess a judgment. So here there's an admission of liability against the partnership. So it needs the consent of all of the partners, general and limited. Parang pareho din to yung diniscuss natin sa 18. What else? Possess partnership property or assign their rights in specific partnership property. What else? Number 5, admit a person as a general partner, admit a person as a limited partner. What else? Continue the business with partnership property in case of dissolution of the partnership due to death, retirement, insanity, civil interdiction, or insolvency of a general partner. Also, specific rights, 1851, same rights as limited partner, right to inspect book, right to inspect, ask that books be kept in the principal office, right to true and full information, and right to formal accounting. Yan. And right to participate in the winding up of affairs of the partnership. How about a general limited partner? A general limited partner is a partner who is general and at the same time limited. Akala nyo joke, no? But the general rule is that a general limited partner, the rights are those of a general partner. So, yung kanyang rights and liability, remember, third persons can go after his personal properties, except in case of his contribution, he is considered a limited partner. Yan. How about in case of death of a limited partner? In case of death of a general partner, the partnership is dissolved as a rule. But in case of a limited partner, hindi ganun ang nangyayari sa hindi yun ang nangyayari sa partnership, hindi siya na-dissolve kaagad. So, remember, on the death of a limited partner, his executor or administrators shall acquire all the rights of the limited partner. And also, may right din siya na yung executor or administrator to make the assignee, kung merong assignee na na-appoint as a substituted limited partner, only if the power is provided in the certificate of limited partnership. Also, estate of the deceased limited partner is liable for liabilities contracted while he was a limited partner, obviously before the death of the deceased limited partner. What else? Charging order, same as in 1814. The interest of a limited partner can be charged. So kung merong utang ang limited partner sa isang creditor, the creditor can go to court and ask for a charging of order para i-charge yung interest ng limited partner sa partnership. Remember here that it may be the interest of a limited partner may be redeemed with separate property of any general partner. This is different from 1814 in that in 1814 even partnership property can be used to redeem the interest charged of a general partner. But in 1862, yung interest charged of a limited partner can only be redeemed with property of general partners. Dissolution, obviously, there is retirement, death, etc. of a general partner that will cause dissolution. So, it will dissolve the partnership, but it can be continued if the right is given to the general partners to continue using partnership property under the certificate of limited partnership. So, there must be amendment also. Yan. What else? Order of payment in 1863. Ito ang settlement ng liabilities. Bayaran muna ang creditors who are strangers, except those to limited partners on account of their contributions and to general partners. Creditors who are strangers first. Number 2, ibalik yung sa limited partners in respect to their share in profits and compensation by way of income. Tapos, ibalik yung kanilang contributions. Yan. Next is you have to return yung amount owing to general partners, meaning amounts advance other than for capital and profits. Ito yung mga inabono nila. Bayaran, kailangan yan ng partnership. What else? Bigay ang profits ng general partners and then balik ang capital ng general partners. So that is the order of payment as provided for in 1863. What else? Amendment or cancellation of the certificate of limited partnership. So, grounds for amendment, change in the name of the partnership, character of the contribution, amount, kailangan mag-amend. Number 2, there is a substituted limited partner, which I already discussed. Additional limited partner, kailangan mag-amend. Additional admission of a general partner, kailangan pa rin mag-amend. What else? If a general partner retires, dies, become insolvent or insane, and if there are grounds for dissolution but the business is continued by the remaining partners, there must be an amendment. What else? Change in the character of the business, change false or erroneous certificate, or else magkakaroon ng liability yung tao who is aware of the false or erroneous statement in the certificate but did not so amend or so correct it. What else? Change in the time for dissolution. Also, if a time for dissolution is fixed, but there is no actual specified time for dissolution. Yan. Or time fixed to return the contribution. Wala talagang nakaspecify. So, fixed time for return pero hindi nakaspecify yung time, also amend. So, any other change na gustong mag-amend ng partners, remember, kailangan nilang iso-amend yung certificate. So, how about in case of cancellation? The grounds are, obviously, the partnership is dissolved by expiration. Kailangan nang i-cancel ang certificate of limited partnership pagka wala ng limited partner. So, kung wala ng limited partners, lahat na lang na natira is general, obviously, they have to cancel yung certificate of limited partnership. What else? Requirements for the amendment. Number 1, it must be in writing, signed and sworn by all members, including yung mga incoming members. So, in case of substituted limited partner, kailangan din niyang pumirma, etc. What else? The certificate must be filed to the SEC. How about for cancellation? Remember that, again, the cancellation must also be in writing, signed by all members, and filed with the SEC as well. So, that's it for limited partnership. Tomorrow or on Saturday, we will discuss additional examples for 1851. And I think that's it. Medyo okay naman. Additional questions for recitation. That will be all for today, class. I hope you have a good day. Thank you.